Welcome, everyone. This is our first employment law update for the year, and we're thrilled to have you online with us. Our last one was in November, and it's definitely a lot chillier than it was then. But again, we're not short of a lot of interesting cases to take you through today and to share with you. I think from an employer point of view, I don't think there's going to be anything too alarming. Quite a lot of confirmation of existing principles, but definitely some interesting cases. My name is Helen Wilsnack, and I'll be facilitating this morning's update. I'm joined by my colleagues in our employment and benefits practice, whom I'll introduce to you as we go along, as we get to the cases that they will be presenting. If you are a regular attendee, though, many of them will be very familiar faces to you. Before we begin, I would just like to run through a few housekeeping matters, which will hopefully enhance this webinar experience for you. As participants, you're all automatically muted and the chat functionality has been disabled. But if you have got any questions, you can pop them in the Q&A and we will try and get to as many of those as we can, time allowing. We won't be providing written answers, but what we will be doing, as we have done for the last few updates, is we'll be providing a recording, which will be available on our website, www.bowmanslaw.com. And then we will also be sending you a high-level summary of the cases that have been discussed this morning with the key takeaway, the key legal principles highlighted for you. And these summaries should be provided to you early next week. So welcome, everyone. Great to have you online. And without further delay, let's begin. Our first case this morning is going to be presented by Sabu Dube, who I'm sure many of you are very familiar with. It is in our invite, we spoke about a cautionary tale around reinstatement orders, and that is our first case, Matabula versus General Public Service Sectorial Bargaining Council and others. Something as Sabu's one of our very experienced dispute lawyers who does a lot of his own presenting in the Labour Court, is sure as a case that's going to be quite, he's going to find particularly interesting. And over to you, Sabu.
Thanks, Helen, and good morning to everyone who's joining us. Thank you for making the time this morning. The citation of the case has been put up, and the employee is Mr. Matabula. So what happened in this case is that Mr. Matabula, who was employed by the Provincial Department of Agriculture and Rural Development and Land Administration, it is quite a long title, so I'll just refer to it as the department. He was dismissed for mismanagement of public funds. Now, aggrieved by his dismissal, he referred an unfair dismissal dispute to the bargaining council. At the bargaining council, it was found that his dismissal was both procedurally and substantively fair. He took that on review to the Labour Court, and at the Labour Court, the arbitration award was set aside. However, the judge was of the view that reinstatement would not be appropriate under the circumstances, as Mr. Matabula, in his evidence, had alluded to the fact that he believed there was a conspiracy that the cadres were trying to get rid of him. There was no further evidence that was given in this regard, but the judge at the Labour Court felt that this was enough to justify not awarding reinstatement as the primary remedy, even though Mr. Matabula sought reinstatement. As a result, Mr. Matabula took that judgment on appeal, and the appeal was focused solely on the point of reinstatement. Mr. Matabula contended that the Labour Court had not properly applied its discretion in terms of Section 1932 of the Labour Relations Act. Now, we know that in terms of Section 1932 of the Labour Relations Act, in the case of a dismissal, the primary relief is reinstatement or re-employment. There are exceptions, of course, and those exceptions are that the employee did not want to be reinstated or re-employed, that the circumstances resulting in the dismissal are such that reinstatement would be intolerable, or that it would not be reasonably practicable to reinstate the employee, or simply because the dismissal was only procedurally unfair. Now, looking at the Labour Court judgment, the appeal court found that, where an employer has dismissed an employee and that dismissal is found to be unfair, the employer cannot then benefit by not reinstating that employee. The onus is on the employer to prove or show that indeed the circumstances surrounding the dismissal are such that the reinstatement of the employee would be intolerable, or that it is reasonably impracticable to do so. The test is an objective one, right? So it's not subjective. You actually have to produce evidence at the arbitration that shows why reinstatement under the circumstances should not be awarded as a remedy. Now, the Labour Appeal Court found that there was actually no evidence at the arbitration except for the employee who is trying to explain why he felt the charges against him may have been trumped up. There was no evidence that spoke to an actual conspiracy, and therefore the Labour Appeal Court found that the Labour Court had actually erred in not reinstating the employee. And this was mainly because the department had not challenged the reinstatement, and the department had not led any evidence as to why reinstatement would not be appropriate under the circumstances. The arbitration award, or rather the judgment of the Labour Court, was then replaced with an order that the employee must actually be reinstated. And I think for me, the key takeaway here is that it does happen at times that, when you're in an arbitration, you feel or you find that the case that you're presenting might not be successful, and there is a risk that the employee may be reinstated. And there's really no way for the company, there's really no way that this person can be allowed back into the company. So under those circumstances, you want to make sure that at arbitration, you actually lead evidence about why reinstatement would not be possible if the employee was successful in arbitration. Because if you don't do it at arbitration, then it's too late to do it at the Labour Court. Thanks, Helen.
Thanks, Sabu. Moving along to a section 197 that Talita, who I know you're all very familiar with and is one of our experts on 197, amongst other things, is going to take us through. It's Africa Online Operations, Mauritius Limited versus Scanlon is the case. Thanks, Talita.
Thank you very much, Helen, and good morning, everyone. Yes, this AOOML case is a decision of the Labour Appeal Court. It's not often that we get Section 197 cases in the LAC, so it is great to have this one again. The LAC considered an appeal from the judgment of the Labour Court, in which it was found that Section 197 actually applied to the facts, and that the contracts of employment of Ms. Scanlon and 13 other employees had to transfer across to AOOML. So just to recap, Section 197 applies where there is the transfer of a business as a going concern. This will be the case where there is an economic entity that retains its identity after the transfer. So you look at whether the snapshot taken before the transfer is substantially similar than the picture that you take after the transfer. And if so, there will be a transfer of a business as a going concern. The employment consequence is, of course, that the new employer must take on the transferring employees. They must do that on terms and conditions that are on the whole not less favorable, and they need to recognize the past service of the employees. Section 197A of the LRA applies in circumstances of insolvency. So where the old employer is insolvent or has entered into a scheme of arrangement or a compromise to try and avoid winding up, then also those same consequences will apply, but with an important difference. In insolvent circumstances or these scheme of arrangement circumstances, the new employer takes on the employees on terms and conditions that are on the whole not less favorable, but the rights and obligations against the employer and the employees, the old employer and the employees, remain there. Those rights and obligations do not transfer across. So in this case, it was a case where Section 197A applied, and the question was whether this Africa Online Operations Mauritius entity had become the new employer where the old employer was placed into liquidation. So the facts are a little bit complex. I'll try and be quick on the facts. But in essence, iWays Management Services was a company that existed as part of the GIN group of companies. And way back in 1990, the Echo group of companies, through its holding company, acquired the GIN group, and IMS was now a subsidiary of the Echo group of companies. IMS, their name was changed to EIMS, and their business was to perform shared services to all of these other Echo group companies. So they provided services like human resources services, legal, finance, business support, sales and marketing, billing, importantly. And that was performed to various countries on the continent where the group had entities. So in 2020, just before COVID, the management decided it was now time to move away from this centralized model, and that was not going to apply anymore. Every entity in the Ecotel group now needed to get their own services in their own markets, and EIMS was not going to provide these shared services to these various countries anymore. So because of that decision, a retrenchment consultation process kicked off in January, and a decision was then made in February that EIMS would be placed into voluntary liquidation. That retrenchment consultation process was put on hold actually because of these subsequent events where it was argued that no, Section 197 applies, we ought not to be retrenched. And the reason why employees formed that view was because of the creation of this new entity, AOOML. And from March 2020, this entity started carrying on the functions of providing the shared services that were previously provided by EIMS. So the Labour Court said no, there was a business that transferred from EIMS to AOOML. It was exactly the same services that were provided. The directors of EIMS were now the directors of this new entity. And another important factor for the court was a communication from the managing director at the time, Mr. Rautenbach, that AOOML would honor at least some of the shared services rendered, and that it would be business as usual. So the Labour Court said it was clear. There was a transfer of a business. It doesn't need to be the sale of an entity. What is important is there needs to be a deliberate handing over or shifting of the business. How that occurs is not relevant. So AOML didn't want these 14 employees, and they appealed to the LAC. And it said, the fact that the directors of EIMS are now the directors of AOML, that's actually irrelevant. What the court needed to determine was whether there was a going concern transfer, so an economic entity that retained its identity after the transfer. It said AOML is not performing the same tasks that EIMS were performing before the liquidation, and therefore it didn't retain its identity in the hands of AOML. What is a bit frustrating in this judgment is that we didn't see any facts around whether the entities in the countries actually at that point started to performing the services themselves, or whether this was a temporary measure or how it actually worked. The facts that we have are that AOML performed the same services, and that is why the Labour Court took this view. So the Labour Appeal Court agreed that there was a 197 transfer. It took into account these factors. There was that communication to all of these entities that AOML would provide continued support. In fact, AOML cherry-picked employees and engaged them on independent contractor arrangements to provide these services. 6 of those employees therefore came across. The activity that was performed was the same. It was the same shared services that were previously provided by EIMS. And a critical factor for the court was the solid SOLID platform. That was provided through a third-party service provider, and that contract was cancelled with EIMS, but a new contract was concluded for the use of this electronic platform, which was critical for billing, collections, and customer support. And this enabled the retention of uninterrupted services that were now provided by AOML. So this particular asset was critical in the court's view. So for the Labour Appeal Court, the fact that key employees were contracted, that was important. The solid platform, that was important. The activities that were previously provided, that factor was important. And the court therefore said this was a transfer in terms of 197A. The employees had to come across. The obligations and rights remained with EIMS.
Thank you, Talita. So, I mean, again, confirmation from the court that it's substance over form, and 197 still apply when the new employer sits in a foreign jurisdiction.
Oh, that is a question that you need to come and ask us in our offices. And we will need to, be very circumspect about that. I don't think so, just from the rule that the LRA has territorial application in South Africa, and the LRA doesn't reach into different jurisdictions. But the problem is if the employer sits in a different jurisdiction and the employees are remaining in South Africa and they are now going to perform the same service that employer or that the old employer was performing, it's complex. Then the foreign employer may need to conclude employment contracts with these employees in South Africa, and that triggers an obligation for the foreign jurisdiction to register an office in South Africa, well, a branch in South Africa. And in that roundabout way, Section 197 may apply because now we have a branch in South Africa. So it is not a simple answer to say no. If nothing else stays behind in South Africa, then I think it is a no, because if you are now going to have a foreign employer having employees, say, in Spain, rendering the services, there isn't going to be an extraterritorial application. The question is, where are the employees going to sit after the transfer?
Thanks, Talita. As you say, not an easy question. And just one last question on this case. Does Section 197 apply to intra-group transfers amongst group companies?
Yeah, it can. The question is there an economic entity that is retaining its identity after the transfer? So definitely, if we are meeting that test, it can apply.
Okay, thank you very much. And we're going to stay with Talita as we move to our next three cases, all of which deal with unfair discrimination in the context, in I think at least two of them, of an automatically unfair dismissal claim. So Talita, the case you're going to be taking us through deals with, I think, a claim for pay discrimination, and it's Labello and others versus City of Johannesburg Metropolitan Municipality.
Thanks, Helen. Yeah, as Helen says, this is an equal pay claim, and it was instituted by about 408 employees against the City of Johannesburg. Again, there is a long history here. So in 2003, the city decided to make use of fixed-term contracts for certain of its positions, and it invited permanent employees to convert their employment contracts to fixed-term contracts. If they decided to do that, the inducement would be to get a 10% increase at the time. And part of this whole project was that new employees, new entrants into the city would be increased. Remuneration of the fixed termers was going to be much more flexible. So they would be able to structure their remuneration to have an entertainment allowance and a cell phone allowance and all kinds of things. And that was basically to enable the employees to get a bit of a tax benefit. The court didn't say anything about that structuring, except that that was something that was actually given flexibility to the fixed termers for. And many of those employees, in fact, did that. One of the employees who complained later on, Ms. Fury, actually indicated that she structured her remuneration to include an entertainment allowance, and she admitted in court that it wasn't used for entertainment, it was just to get more money in hand. So Imatu and some who didn't like this idea of fixed-term contracts, and they declared a dispute in 2004. In 2006, the South African Local Government Association concluded an agreement where this dispute was settled, but that was without any mandate from the city or any of the other municipalities. So the City of Johannesburg took that on the review to the Labour Court to set that settlement agreement aside, and that was in 2008, and 4 years later, in 2012, the city and the unions ultimately reached an agreement. So in terms of that agreement, that 2006 settlement was declared null and void. The city agreed to withdraw its review application, and all the employees who were identified in that collective agreement, that settlement agreement, would now convert back to permanent contracts in terms of this collective agreements. In terms of the collective agreements, these employees would retain their total package remuneration. It would include now a basic salary, allowances, subsidies, employer and employee contributions to benefit funds, and a service bonus, so a 13th check. Future wage increases would be based on the employee's basic salary, not on their total cost to company, and that was in line with the practice for existing permanent employees. In order to determine this basic salary, the collective agreement included a method in terms of which this would be, and that calculation made provision for an amount equal to 8.33% as their 13th check, their service bonus. And then lastly, there was provision made for a sunset clause. So those employees who had earned above the band that applied to other permanent employees in that position, those employees would not receive an increase until their basic salary was now in line with what the other employees were earning. So Mr. Labello and his fellow employees thought this is very unfair. Two things here are just very unfair. The first is permanent employees get a 13th check. That is paid once a year. They are not getting a 13th check, so they say. And secondly, this story of not getting increases, that is unfair discrimination. So they argued that the basis, the ground for discrimination was status. And that status was their status as fixed-term employees. They said fixed-term employees are vulnerable, and it is just because we were fixed terms that we are now subject to the sunset clause and the exclusion from the 13th check, and that is very unfair. So the relief that they sought was increases from 2012 to 2022, 10 years, and payment of the 13th check from 2012 to 2022. Now, we know now, because of the Naidu matter, that where an applicant alleges discrimination on a ground that is not listed in section 6.1, they need to show there is a ground, firstly, and secondly, that that ground affects their human dignity in a comparably serious way, as would a distinction on one of the listed grounds. That's a high hurdle. It is really not easy to make that case. But that is the test. So in order to meet that test, Mr. Labello then had to show how his human dignity was now affected by this massive unfairness. So he said he was frustrated. He felt degraded because he was not treated the same as other permanent employees that got increases. He said he lost his house, he had to relocate, he had to move his children to a new school, and he had to sell his vehicle. And he was mocked by other employees who didn't convert way back in 2004 when this initial conversion took place. But then under cross-examination, he conceded, no, he sold his house actually for a profit. He moved his children to another school because that school was now closer to his new house that he bought. And he wasn't able to explain how he was mocked, because at the time, in 2012, when he was now becoming a permanent employee again, he was 33% more than the other employees, and that is why the sunset clause applied to him, again, or equity again, between all of these employees on the same level. As I mentioned, there was also another employee, Ms. Fury, and she said that after they were converted to fixed-term contracts in 2004, they never felt like part of the city anymore. They were treated unfairly in a discriminatory manner. Her self-respect, her morale, her productivity, everything was affected. Bearing in mind that she agreed and that she got an increase at the time. So under cross-examination, she conceded that they had experienced insecurity as fixed-term employees now, and that the conversion to permanent contracts provided them actually with a sense of job security. And she also considered that as a fixed termer, she was able to structure her remuneration that in a way that didn't apply to the permanent employees. So the cell phone allowance, the entertainment allowance, that allowed her to get more money in her pocket. So the court was not convinced about this impact on human dignity that was allegedly suffered. Then it was also apparent from the evidence that actually there was a service bonus, a 13th check, because of the way in which the remuneration was calculated. Excuse me. So in response, the city said, listen, those contracts that were converted way back in 2004, the employees got a 10% increase at the time. They got the flexibility to structure their remuneration. In fact, they also qualified for a performance bonus if they met certain performance targets. With the conversion in 2012, some of those employees had earned way more than what the permanent employee group had earned. And it was about 900 employees in the entire cohort, but 97 of those employees had earned more. So that was the reason for the sunset clause. We had to now bring those employees in line. They could have just simply changed their terms and conditions immediately through agreement, because a collective agreement was being concluded. They could also, but they chose not to do that. They said, no, we are not going to, just cut employees' remuneration by 30%, just to bring them in line with what other people are earning. It is a recognition of the fact that employees have planned, they have put children in schools of their choice. Let's give them time to adjust, and let's not just simply reduce salaries. So the Labour Court then discussed very clearly the requirements to be successful in an unfair discrimination claim. So the court said, Section 6 of the Employment Equity Act does not prohibit differentiation. It prohibits unfair discrimination. Where that ground is not in 6.1, then the applicant must prove that it affects human dignity in a comparably serious way. Then, thank you to Judge Connie Prinsloo. This test of when is someone actually affected in their human dignity, that is not something that the courts have explained in a lot of detail yet. So they have said from Hodgson, Naidu, it is about this whole point about human dignity. But this ground, how do we determine whether this is actually affecting people in their inherent human dignity? And Judge Prinsloo says it is about characteristics that are personal to the individual. If we look at the listed grounds, it's race, it's sex, gender, it's HIV status, it's language, it is culture. Those things attached to the person, religion. So where we are looking at a ground like status as a fixed term employee, that is just not the same. It is actually quite an external factor. And funny enough, in this case, chosen by agreement with the individual employees. So the court said, then moving on to the wage increases, this was entirely rational and fair. It only applied for as long as the employee's salary exceeded the applicable band. So for some employees, it was 3 months. For some employees, it was 2 years. For some employees, it was 18 months. But there was nothing irrational or arbitrary in relation to that sunset clause. It was purely a way to achieve equality and parity in pay over time. And the court said what they had forgotten was that since 2004, they had received higher salaries than the employees who were on permanent contracts. So for this long time period, these fixed termers actually got more in their pocket than the permanent employees. So the sunset clause, the court said it didn't apply to human characteristics, but to the group of employees who earned above the applicable band, and there was nothing discriminatory about that. As regards the differentiation in the service bonus, the 13th check, the court asked counsel for the applicants whether he agreed that if in rands and cents there was no differentiation, then that was the end of the matter, and he agreed. So the court said, yes, there's differentiation in the intervals of payment, because on the fact it was established that that additional 8.33% constituted the 13th check. For these new permanents, the converted ones, that was paid monthly with their normal remuneration. They could have set that aside and saved it, and then like the other counterpart employees at the end of the year when they got their lump sum, that would have been the same. So there was no differentiation in the value or in the amount, only differentiation in the intervals of payment. And the court therefore said there was no differentiation needed. The court needn't look further into that issue, and the claim was dismissed. It is possible, I think, that someone might say that that is now unfair discrimination, that some people get it paid over 12 months, other people get it paid as a lump sum, but that was not the case here.
Thank you very much, Talita. Useful confirmation of the principles on unfair discrimination. Roz, moving across to you, you're all very familiar with Roz, and a big thank you to her because she is the one who actually puts this together for us. Roz is going to take us through a case, an interesting case dealing with criminal records in the recruitment process within the context of discrimination, O'Connor versus LexisNexis.
Thanks, Helen. Good morning, everyone. All right, let me just jump straight into it. So what happened in this case is Mr. O'Connor was looking for a job. He had applied for the position with LexisNexis and sailed through the interview process. And part of that process was to declare if he had any criminal record. He submitted in his form that he had a criminal record for theft, but that the record had been expunged. LexisNexis was happy. They offered him employment, and he accepted the offer. Now, one of the clauses in the contract itself said that the offer was conditional on them being satisfied with a criminal record check. Having accepted the job offer with LexisNexis, he then resigned from his current employer. The new job with LexisNexis was going to be completely remote. So he upgraded his Wi-Fi, he bought a new laptop computer, set up his home office, and spent quite a bit of money, by the sound of things, getting ready for this job. What happened between the signing of the contract and starting his new job? LexisNexis then conducted a more extensive criminal record check. And they discovered that he actually had various records for theft, fraud, and defeating the course of justice. As a consequence of that, and relying on the condition in the contract, they contacted him and said, we are withdrawing the offer because you've got all these criminal records. He approached them and said, look, please, this all happened 20 years ago. I really need the job. The criminal records have been expunged. And LexisNexis said, no, we can't have someone with this extensive criminal history working for us. O'Connor then referred the dispute to the CCMA, and he claimed one, automatically unfair, alternatively an unfair dismissal, and he claimed unfair discrimination based on an arbitrary ground. Now, he went to conciliation. The employer did not pitch up, and following the conciliation, he launched an urgent application straight to the Labour Court, and was seeking essentially had three causes of action and was seeking relief in respect of those three causes of action. The first cause of action was an automatically unfair, alternatively an unfair dismissal. The second cause of action was for specific performance. And the third cause of action was unfair discrimination. Now, the first thing that the court had to do was consider whether or not the application was in fact urgent. The employer wrongly, I think, objected to urgency and said this application is not urgent because it's self-created urgency. He didn't act immediately to get to court. Instead, he waited until after the conciliation had taken place. Now, what then happens is that the court looks at the three different disputes to see if it's actually urgent. And insofar as the test for urgency is, there is a requirement, or in order to be successful, you must be able to convince the court that you do not have, or you will not have, substantial redress if you don't get urgent relief. So the court looked first at the claim for automatically unfair, alternatively unfair dismissal, and said the Labour Relations Act provides a remedy or a process for a remedy if you are looking for an automatically unfair dismissal, and it does not envisage an urgent application. It envisages either a referral to the CCMA for arbitration if it is the unfair dismissal, alternatively to the Labour Court for adjudication. And the court said that is what the Labour Relations Act provides. There is a requirement that labour disputes must be expeditiously resolved. We all know that that doesn't happen because of the state of the court role, but the court was satisfied that that does not then give this employee the right to jump the queue in respect of this claim. So the court said this is not urgent and dismissed the urgent application insofar as that claim was concerned. The court then looked at the second claim, which is the claim for specific performance. Now, in establishing his case for urgency, the employee had talked about the fact that he now didn't have a job. He had forked out all this money to set up his own office, to get ready so that he could now perform, and he was at risk of now not being able to pay his rent. And the court accepted that that was then urgent and said, well, if he waits in the queue to get to court in a year's time, he's not going to get substantial redress, because the substantial redress on a specific performance is that he then starts working for LexisNexis, whereas a claim for damages was unlikely to give him the substantial redress that he needed. So the court accepted that dispute was urgent. And then insofar as the unfair discrimination dispute was concerned, the court looked at the process, the rules of court, which ordinarily provide that an unfair discrimination case is dealt with in terms of Rule 6. Now, Rule 6 provides that you issue a statement of claim, there's an opportunity for a statement of response, and then the matter goes to trial and evidence is actually led. But the court looked at this and said, but this is not prescriptive. The LRA does not say you have to follow this process. And the court was again satisfied that waiting to go through a full court trial was not going to give the O'Connor substantial redress. And then decided on that basis that the matter was urgent and could be determined on the papers. Now, one of the considerations for a determination on papers, so when you have affidavits, is there a material dispute of fact or not? Where LexisNexis made a critical error, in my view, is that they did not deal with the substance of the case. They said the Labour Court does not have jurisdiction, and then they had all the reasons that the court had determined that this should go to adjudication, it shouldn't go to, it shouldn't be dealt with on the papers, etc. And they said it was self-created urgency. And that was the sole basis on which they challenged this case. And the court said, well, we disagree with you. So before I go into the rest of it, it's a lesson probably for the lawyers and those of you who actually do your own cases in court, is deal with the substantial merits of a matter. Don't just set out that it's not urgent and try and get things kicked out on a technicality, because it could be problematic for you down the line. So once the court had determined the issue of urgency and accepted that the matter was properly before the court and the court had jurisdiction, the court then looked at the claim for specific performance. Now, the court, in looking at the claim for specific performance, had regard to the contract that was signed by both parties, and there was that clause that said this offer is conditional on us being satisfied that you have a clean criminal record, that, well, you don't have a criminal record. And the court said because there were all of these other criminal records or incidents that hadn't been declared and that the employer had found out after offering the position, it was entitled to withdraw the offer, and there was no basis on which to claim specific performance in terms of the contract. So O'Connor failed in that challenge. Then the court turned to the third issue, and that's the issue of unfair discrimination. And what the court looked at here was the requirement to have a clean criminal record an inherent requirement of the job? And the court seemed to accept that if it was an inherent, if it went to the core of the job requirements, then it might warrant a dismissal or a retraction or whatever. But in these circumstances, the court said, well, we now have an employee. Yes, he's got these criminal records. Yes, he's done these things in the past. He's going to be working from home. So there's no risk of him coming to LexisNexis premises and stealing from his colleagues, etc. Also, there's not much damage he can do. He was going to be a data capturer. So he was going to be online and then really capturing cases that came in, uploading them, and doing that sort of function. And the court said, but there's not really a requirement there that that you have someone who hasn't got a criminal record. Again, I think LexisNexis made a mistake because it didn't set out why it was necessary. So we don't know if there was an inherent issue that they were concerned about, possibly because of the charges of defeating the ends of justice or the fraud charges. But on the face of it, the court was satisfied that it was not an inherent requirement of the job, and therefore found that withdrawing the offer based on the criminal record was an arbitrary ground, and that it constituted what was discriminatory, and it constituted unfair discrimination. So it was a very, very interesting case. And essentially, the court then ordered that LexisNexis honor the terms of the contract and that they take O'Connor into their employment within 10 days of the court order. Now, I'm not sure, this judgment came up very recently, so I'm not certain if it's going to be taken on appeal and what the outcome is. But having read the judgment, it is clear that on the issues, the takeaway, or the key takeaway for me, insofar as this issue of discrimination and criminal records if you are going to rely on a criminal record, either as a reason not to offer a job applicant a position, alternatively to withdraw a job application, or to dismiss, it must go to the root of the nature of the relationship. So, for example, if you are employing a CFO who is going to be in charge of your finances, and the CFO has a criminal record for fraud or theft, that could absolutely justify this decision. But it's not a one-size-fits-all. You must have regard to what is it that you're seeking to protect the business from. And if it's actually not going to, if it's just a principle that we don't do that, that is not enough. Thanks, Helen.
Thanks very much, Roz. Our final unfair discrimination case relates to age. Nadine, their partner in our Santon practice, also specializes in data privacy, is going to take us through this case. It's Amara versus Thames Meat Wholesalers. Thanks, Nadine.
Thanks so much, Helen, and good morning, everyone. Whilst this case isn't automatically unfair dismissal judgment, it actually did not deal with that issue. The case concerned the issue of duress or being coerced into signing an agreement. And briefly in this matter, the employee was employed by Thames Meat Wholesalers as a driver. Whilst at work and offloading a truck, the employee sustained injuries which rendered him unfit to work. Now, following several medical evaluations, the employee finally returned to work a few months later. And upon his return to work, the parties entered into a mutual separation agreement titled early retirement. Now, unfortunately, the judgment doesn't really address the background facts into what led up to the parties concluding this agreement, but it was noted that the agreement was in full and final settlement of all claims. The employer proceeded to pay the employee in terms of the mutual separation agreement, and the employee then sought to take out his payout from the retirement fund. Now, dissatisfied with the amount received, the employee then referred an automatically unfair dismissal to the applicable bargaining council. And in his referral, he alleged that he had been dismissed because of his age, and that the employer offered him early retirement and severance pay that was less than what he was entitled to. The matter was conciliated between the parties and remained unresolved. And the employee proceeded to institute an automatically unfair dismissal claim based on age before the Labour Court. Now, at the Labour Court, and for the first time, the employee alleged that he was in fact coerced into signing this early retirement agreement. He contended that upon being furnished with a copy of the agreement, the employer denied him the opportunity to discuss and obtain advice from his children. The employer said he had no time. The employer shouted at him and pointed to the employee where he was required to sign on the agreement. And on this basis, the employee said he was coerced into signing it. The employer, on the other hand, of course, denied this. They denied that the employee was dismissed and contended that the employee voluntarily entered into this early retirement agreement. So, in effect, what the Labour Court was required to determine in this matter was whether the early retirement agreement entered into between the parties was binding on them. It is an established principle in our law that a contract entered into between parties is binding on the parties and therefore enforceable, unless it can be shown, amongst other things, that the contract is invalid or it is contrary to public policy or it is unlawful. And in this regard, the court noted that it is possible for a contract to be vitiated by duress or coercion, where there is intimidation or improper pressure that renders the consent of the party that is subject to the duress not true consent. Now, intimidation may be exercised by way of physical force or indirectly by way of a threat of harm. And in this regard, in order to obtain an order that sets aside a contract based on duress, one will be required to show that they either incurred actual violence or a reasonable fear must be shown, and such fear must be caused by a threat of considerable evil to the person or to their family. And of course, the duty to prove this, or the burden of proof, rests on the party that is raising the defense of duress. So looking at the facts in this matter, The court noted that the employee contended he was subject to duress because the employer told him he had no time, he shouted at him, he wasn't allowed to get advice from his children, and he signed the agreement. The court sort of questioned the employee to say, well, did you raise any concerns with the agreement or the amount set out in the agreement? And the employee's response in this regard was simply that his relationship with the employer was one of a boy and boss. And, he didn't feel like he could raise anything. But the picture painted by the employee was ultimately that there was no actual violence. And it also did not show a reasonable fear caused by this considerable evil to the employee. The court said ultimately the employee could have refused to sign it. The employee had a choice to leave the employer's office without signing the agreement, and he chose not to do so. On top of that, the court also noted that the employee did not immediately refer the dispute to the bargaining council. Instead, it was only after he raised concerns about the amount that he received and that he was unhappy about his retirement fund payout that he referred the dispute. And further, he did not raise the issue of duress or coercion before the bargaining council. The first time he raised this argument was before the Labour Court. From the facts, the Labour Court sort of ascertained that the employee did know and at least understood the terms and conditions of the agreement, and also accepted that the conditions of the agreement were in full and final settlement of all the claims. So on a consideration of all the evidence, the court found that the employee had failed to prove the existence of duress or coercion, and that the early retirement agreement was binding on the parties, and as a result, his automatically unfair claim was dismissed. So I think this case fairly short and brief, and whilst it wasn't concerned with an automatically unfair dismissal per se, what is apparent is it's quite a high burden to show or prove duress and coercion. We always advise clients, employment is based on principles of equity and fairness, and it is important to give employees an opportunity to consider agreements, to take advice or to consult with family members. But just to note that if one is alleging duress or being coerced into signing an agreement, one has to show actual sort of force or the reasonable threat of harm, which must demonstrate a considerable evil on that person or their family, which is quite a high burden to prove. Thanks, Helen.
Thanks, Nadine. And interesting because in jurisdictions like the UK, an agreement is actually only enforceable with an employee settlement agreement if a solicitor's certificate is attached, saying they've taken legal advice. So it's one area where South African employment law is actually a bit more flexible. We just got one question has been put into the Q&A before we move on to our next cases. And that is, does the Lexis case mean that we can't have a recruitment policy that categorically says the company will not employ anyone with a criminal conviction for particular listed crime? So you can obviously, it depends on the nature of the business. If you're a financial institution and it's the listed crimes go directly in relation to fraud or theft, etc. But I think what our takeaway is not that you need to change your recruitment policy, but that we work in a fairness-based employment system so that you will need to be able to show it, regardless of what your policy is, you'll need to be able to show that if you turn someone away based on a criminal conviction, it relates to inherent requirements of the job. Hopefully that addresses that question. Our next three cases are going to deal with unfair dismissals, and we've got two of our very talented senior associates who are going to be presenting these for us. I'm going to start with Sean Gaffney. He's a senior associate based in our Cape Town practice area. The first case, SACTU versus FAPI, it deals with bumping, which is obviously a very interesting principle and be quite tricky to apply. And the second case that Sean will just go directly into after that is dealing with admissibility of evidence, is Brawns versus Wilkes and others. Thank you, Sean.
Thank you, Helen. Good morning, everybody. So essentially, this case deals with an unfair dismissal claim, an unfair retrenchment claim by members of the South African Clothing and Textile Workers Union, SACTU, in the context of a large-scale retrenchment. So the basis of their claim was really that the respondent or the employers failed to apply the last in, first out principle, and in particularly the practice of bumping. So there were procedural issues that were challenged, but this case only deals with the substantive fairness of the dismissals. So brief factual background, the employers, they were a father and son, Garen and Ian Fafi. They had two different farming operations in the KZN region, one for vegetables, another one for macadamia nuts. Following a terrible season for the vegetable farm in 2019, they contemplated closing the vegetable farm, but retaining the macadamia farm. This was based on, the macadamia farm's economic viability and the fact that they were losing money from the vegetable farm. Following this, they then commenced a retrenchment process in terms of Section 189A of the Labour Relations Act, and letters were issued to all 23 vegetable farm workers. In this letter, they referred to the fact that the vegetable farm, was working at a loss and the economy was in decline. Following consultation, the farmers decided to close the operations of the vegetable farm, and they proceeded to retrench all 23 workers on that farm, 15 of whom have, referred an unfair dismissal claim to the Labour Court, and they are the applicants in this matter. Essentially, the court said that the operational requirement to close the vegetable farm, that was common cause. So there was no challenge as to why the vegetable farm had to be closed. What was in dispute was the identity of those selected for retrenchment. So vegetable farmers versus the macadamia farmers. The employees argued that because some of their members, the vegetable workers, had longer service, that the farmers should have applied last in, first out and bumping, and they should have essentially retrenched macadamia farm workers who had less years of service and replaced them with vegetable farm workers who had longer years of service. The employees argued that the skills were comparable, and the vegetable workers had also spent, many occasions working on the macadamia farm. Of course, the farmers disputed this. The crux of the employer's argument was that bumping was not viable because macadamia farming is quite different and more complex than vegetable farming. The nature of the work of vegetable farming was quite simple. It involved, planting, harvesting, sorting and packing vegetables. But with macadamia farming, it was far more complex, requiring specific training in processes, particularly in relation to the cultivation of the macadamia nuts, irrigation style, watering, desuckering, etc. In respect of training for the job, the employer argued that it takes between 3 to 6 months of on-the-job training for vegetable farmers. But on the other hand, it takes 1 to 2 years on-the-job training for a worker on a macadamia farm. So the difference is quite substantial in how long it takes to train a particular worker on those farms. And that there's also a higher degree of judgment required from workers on the macadamia farm because of the sophistication of the systems and the long-term growth of the trees. The employees, on the other hand, they maintained that the work done between the two farms were comparable in nature, and that a vegetable farm employee of long-standing service still should have been replaced by a macadamia nuts employee. The evidence that they led was quite limited. It was really just one witness that said that they raised the issue of bumping and that the employer stated that it was not viable. So I don't think they put forward a very strong case here. But essentially, the employer maintained its view that the skills were not interchangeable. The macadamia workers had very specific training that the vegetable workers didn't have, and they couldn't just simply replace them. It was also argued by the employer that it would actually be unduly onerous on the employer to train the vegetable farm employees on the intricacies of the macadamia nut farming. And the macadamia farm was working well. They had a full staff complement, and there was really no reason to tamper with a very viable operation. So in this matter, the court looked at the seminal case on bumping, which is Porter Motor Group versus Karachi. In this case, the Labour Court explained the principles underpinning bumping and said that bumping is situated within our last in, first out principle, which is rooted in fairness for well-established reasons. Longer-serving employees have devoted a considerable part of their working lives to a company, and their experience and expertise is an invaluable asset. However, the Labour Appeal Court in this matter cautioned that bumping does not apply to employees in a different grade if the longer service employee cannot actually do the work of the employee with the shorter service in that grade. And this limitation applies more frequently where the competence, technical or professional knowledge or experience and skills are involved. where the necessity arises of retraining those who are transferred, this should be done unless it places an unreasonable burden on the employer. So the Labour Appeal Court in Karachi, while promoting the practice of bumping, they do draw a line in the circumstances in which the skill sets of the employees were not compatible and where the training requirements would really be unduly burdensome for the employer. So in short, the court held that the employee's case was unconvincing. The employee's actions in retrenching only the vegetable farm workers were reasonable and economically viable, and the skills were not actually comparable. So the key takeaway, I think, for this case is that, you know, while bumping is a valid practice to reward long-standing employees, it cannot be applied in circumstances in which those employees do not have the skills of others and where it would be unduly burdensome on the employer to upskill those employees. The employees were unable to persuade the court that the selection criteria was unfair and they didn't make out a compelling reason for LIFO. The court then essentially dismissed the applicant's claim and there was no order as to costs.
Thanks, Sean. It's good to have confirmation on those principles and bumping, and then I think the next one is Braun.
Sure. So in Braun and others versus Wilkes, this case is quite noteworthy for employers as it provides some guidance on, you know, confessions made in the context of disciplinary matters. So in this case, the appellant, who was Mr. Braun's, he was employed by the South African Police Service as a financial clerk. His duties involved, amongst other things, the management of remuneration for work done on public holidays and coordinating and controlling the budget at the police station. The allegations against him was that he misrepresented that himself and two of the other appellants, being his wife and sister-in-law, were entitled to overtime payments, knowing that they were actually not entitled to such overtime payments. And they used the system where they will pay these overtime payments that were not actually due to them. So the wife and the sister-in-law were also alleged to have defrauded and prejudiced the state by not informing SAPS that they had received these overtime amounts that were not due to them. All three of the employees were charged with fraud and conspiring with each other to defraud SAPS. They were dismissed by SAPS and their unfair dismissal claim, they referred an unfair dismissal claim to the Safety and Security Sectorial Bargaining Council, but their claim was dismissed. Aggrieved by this, they then took the matter to review. They lodged a review at the Labour Court, and the Labour Court ultimately dismissed the review application. And they then appealed to the Labour Court. And so in the evidence that was laid, it was common cause that all three employees received these unauthorized payments and that they were not due to them. They didn't work the overtime. It was also common cause that Mr. Braun's made a confession that he had done this and that he had committed this fraudulent conduct before a magistrate. He had made this confession and the magistrates had given evidence at the arbitration. So some of the key principles that were outlined by the Labour Appeal Court in respect of confessions made, you know, in the context of a labour inquiry, a confession is an acknowledgement on part of the employee of fault or wrongdoing or breach of a rule. In a disciplinary matter, an employee who relies on a confession has the onus to prove that the confession made was valid. And the only way that they can prove that it's valid is if they can establish that it was freely and voluntarily made without undue influence, coercion, or intimidation from the employer or any other person, and that the confession was also clear and unambiguous, and that the employee understood the consequences of the confession. In labour matters, though, the confession doesn't amount to a plea of guilty on part of the employee, and an employer cannot just dismiss the employee based on the confession alone. Where there is a valid confession, an employer is still required to follow a fair procedure and determine if there is a substantive reason to terminate the employment relationship. One of the questions that came up in the case was whether a confession can be considered invalid because it was made in fear of criminal prosecution. And the question and the answer to this, as with most cases, it really depends on the circumstances of the case. A confession in these circumstances could potentially be considered involuntary or influenced by a promise or threat, and therefore inadmissible or unreliable. But this will not be the case where the confession is made willingly and is corroborated. One of the arguments made by Mr. Braun's confession, by Mr. Braun in making the confession, was that his confession was invalid because it was made before he had information relating to any disciplinary charges against him. So he had given the confession to the magistrate before the employer had instituted disciplinary proceedings against him. The Labour Appeal Courts, in my view, correctly found that this has no merit. The charges of misconduct against Mr. Braun were based on evidence gathered by the South African Police Service, which included the confession. Confession in this context forms part of the investigation into the employee's conduct, and it is not made first without finding, made first before finding out what information the employer has. While a confession can inform the charges against the employee, it's not the only factor in determining the outcome of the disciplinary proceedings. An employee who has confessed to an offence can still challenge the confession itself in the disciplinary inquiry. They can challenge its reliability and present evidence to prove their innocence or, mitigate the severity of the sanction. The key takeaways in respect to this matter is, a valid confession by an employee to acts of misconduct can be considered by an employer, but the confession cannot on its own justify an employee's dismissal. An employer is still required to follow a fair procedure and show that the dismissal is an appropriate sanction in the circumstances. The court ultimately dismissed the appeal because the magistrate had given evidence at the arbitration to say that the employee had made the confession, and the magistrate stated that, he inquired into the voluntary nature of the confession, and there was no indication that the statement was not voluntarily made or made under duress. This appeal was therefore dismissed.
Thank you, Sean. It's confirmation that you need to take a cautious approach on evidence. We're going to now hand over to Amanda Mokonwane, a senior associate in our Johannesburg practice area. And Amanda is going to, I think that she's going to do the next two cases for us. Both of them deal with reinstatement in various contexts. The first case is Maralung Local Municipality, and that is reinstatement when a reinstatement order was set aside. And then the second case is in the context of a fixed term contracts and expectation of renewal of the fixed term contracts. Thanks, Amanda.
Thank you, Ellen, and good morning to everyone, and thank you for joining us this morning. So the first case of Maralung.
Amanda, I'm not sure if it's just me, but your sound's quite low.
Is it low? Can you hear me now?
Thank you. I think that's better.
Perfect. Thanks, Helen. So thank you to everyone who's joined us this morning. We really appreciate you taking your time. The first case of Maralung Local Municipality, and I believe Terry has set it on the chat. This was a review of.
And I'm so sorry to interrupt again. It's still, I think people are still probably battling to hear a bit.
Okay, let me see if I can just increase the volume in this.
Thank you. Lawyers and technology is not do not necessarily go hand in hand.
Can you hear me now? Hello?
Thanks, Amanda. I think that's a bit better.
Okay. So the first case is a review application against an arbitration award issued by Commissioner Mafachari, wherein she found the employee's dismissal to be substantively and procedurally unfair. Now, what had happened in that case was Mr. Machibane was initially employed by Mopani District Municipality for a period of 5 years, where he could sign direct payment agreements.
Amanda, I'm so sorry to interrupt. I think people are still battling to hear. So I think what we might do, just while we get your sound sorted out, we will move to Nadine. Nadine, are you happy if you come in with your case, Voyaseko case, which deals with temporary employment services. I think we always have to have one of those in our update. And Nadine, before you kick off with that, there was one question, additional question on the O'Connor matter. And that question was it argued in the case that the bigger issue is, in fact, the failure to disclose? The employee was clearly aware that he had to discuss his criminal record, but he chose to do so only in part. And then the question is the failure to disclose in the circumstances not dishonesty, not in fact dishonesty that warranted dismissal?
Helen, I think Rosalind has dropped off. I haven't had the opportunity to go through that LexisNexis case in detail, but I think from what I understand from Ros was that LexisNexis didn't put through any case. So it wasn't actually an argument put before the court. It's certainly something to consider. Of course, the individual wasn't yet employed, so there was an offer of employment that they sort of retracted it and put through. But the issue of a failure to disclose, whether that is in part, can constitute dishonesty. Again, I think the importance of the judgment also talks to the inherent requirements of the job and what it leads to in terms of your role concern. So if the disclosure either impacts due to a conflict of interest or one's ability to perform the role, it certainly is something that an employer can take into account and institute disciplinary action in respect of. I hope that addresses the question. Moving on to temporary employment services. In this matter of Vuyisika versus the CCMA and others, the court was required to determine whether the parties were engaged in a relationship which involved a temporary employment service, which is commonly referred to as a TES. Now, in this matter, the employee concerned was employed by the AFMS group, and in 2013 was assigned to the National Prosecuting Authority, briefly the NPA, to perform the services of a switchboard operator. Now, her role primarily concerned answering calls and ensuring that the calls were transferred to the relevant individuals at the NPA or advocates at the NPA. And between 2013 to date, her employment had in fact transferred between different service providers and finally back to the AFMS group. But notwithstanding this, throughout the entire period, she continued to render services to the NPA as a switchboard operator. Now, in exchange for services, AFMS claimed an amount of approximately 15,000 Rand per month from the NPA, and the employee's wage from this was approximately 5,500 per month. The employee noted, however, that she was not being remunerated at the same level as her counterparts performing the same role. And in this regard, the position of switchboard operator was a graded position in the public service with a salary starting from around 145,000 Rand per annum. So it was estimated that in her position, given her length of tenure, she would probably be earning around 200,000 Rand per annum if she had been employed directly by the NPA. But she was not remunerated as an employee of the NPA. She was an employee of AFMS and was accordingly remunerated by the service provider. So against this background, the employee instituted a dispute at the CCMA and sought a ruling that she is deemed to be an employee of the NPA, and on this basis that she be remunerated equally to her counterparts employed by the NPA. Now, we are all aware, and as Helen mentioned, we all know about temporary employment services, and that Section 198 of the LRA regulates temporary employment services and defines a TES as any person who, for reward, procures for or provides to a client other persons who perform work for that client and who are then remunerated by the TES. And a person who performs services provided to a client is the employee of the TES. Further, Section 198 capital A of the LRA regulates TES employees earning below the earnings threshold. And this section provides, in brief, that TES employees who are not performing a temporary service for the client, such employee is deemed to be an employee of that client for purposes of the LRA. And further, an employee deemed to be an employee of the client must be treated on the whole not less favorably than an employee of the client performing the same or similar work, unless a justifiable reason exists for the different treatment. Now, just as a reminder, a temporary service under Section 198 capital A is defined as sort of work where you're working for a period not exceeding 3 months, where you are a substitute for an employee that is temporarily absent, or where the temporary service is defined as such in terms of a bargaining council collective agreement or sectoral determination or declared as such by the minister. So in this matter, the CCMA Commissioner was accordingly required to determine, amongst other things, whether the AFMS group was a TES, as defined in Section 198 of the LRA, or rather a facilities management company, as it alleged, and then whether the employee was deemed to be employee of the NPA. Now, briefly, the CCMA Commissioner found that the employee's services were associated with the business activities of AFMS, and AFMS was required to render boutique services to the NPA. The Commissioner indicated that the service level agreement concluded between AFMS and the NPA was not a sham, it was a service level agreement. And on this basis, the Commissioner held that the employee had failed to prove that AFMS was a TES. So in essence, what it appeared to be the case was that the CCMA Commissioner applied the test of whether the service level agreement between AFMS and NPA was a sham. And on the basis that the employee could not show that it was a sham, AFMS was not a TES. The employee was obviously disgruntled by this outcome and sought to review the arbitration award. Now, despite being 31 weeks late in seeking to bring the review application and also failing to provide any sort of proper or detailed explanation for the delay, the court was still of the view that the dispute gave rise to the important issue of considering whether parties engaged in a relationship involved a TES, and it was in the interest of justice for the court to exercise its discretion to consider the merits of the review. So, despite no valid explanation, the court still decided to hear the merits of the review, given the fact that it involved this question of the TES. Now, the court, referring to recent case law authority, noted that in order to determine whether an entity is operating as a TES entails an examination of the substance and true relationship between the parties. Now, the relevant factors that may be considered as part of this assessment include the degree and control to be exercised by the client over the employee, so by the NPA, whether the employee was integrated into the organization of the client and was part of their workforce, the manner in which the employee performed their work, and also, of course, the provision of tools and work equipment. These were just some of the factors that one had to consider in determining the true substance of the relationship between the parties. Now, the NPA argued that there were no provisions in the service level agreement between it and AFMS that granted the NPA overriding authority or control in the manner in which the services were provided. And of course, emphasized this lovely provision that said AFMS was to deal with the labor issues in the agreement. But looking at the agreement, the court noted certain provisions in the agreement and having regard to the relationship between the parties that were relevant to the matter. The first was that the service provider employees were subject to, bound by, and were required to comply with the NPA's policies and procedures. They were also subject to all your vetting processes and security sort of processes that were to be undertaken by the NPA. Specifically relevant to this employee in the position of switchboard operator, the agreement provided that the employee was required to seek management approval from the NPA to make international phone calls, and a project manager appointed by the NPA was in control of the services and was granted the authority to give instructions from time to time. The court, of course, referred to the famous Constitutional Court judgment of assigned cases, in which it was confirmed that the purpose of the 2014 amendments to the LRA was really to provide greater protection for marginal workers who are performing temporary employment services and to allow them to realize their constitutional right to fair labor practices. And Section 198 capital A was thus implemented to fill this gap in the accountability between client companies and the employees who were assigned to them to render services. In the present matter, the employee had been working for the NPA for more than 3 months. I mean, she'd been working there since 2013. She was not performing a temporary service as defined, and she fell within the vulnerable group of employees that Section 198 capital A of the LRA aims to protect. So all that was left to determine by the court was whether AFMS was a TES. In this regard, the court noted that the commissioner was not asked to determine whether the service agreement was a sham, but rather to evaluate as a matter of law and in view of the substance of the relationship between the parties, whether AFMS provides services as contemplated in the definition of a TES. The commissioner did not consider the nature of the agreement, and the court found that it could not be disputed that AFMS provided persons to work for the NPA for reward. The service level agreement required employees to be bound by their policies and procedures, and this amounted to overall control by the NPA of such persons. And in addition, the employee was inherently integrated into the NPA organization. So in these circumstances, AFMS was accordingly regarded as a TES, and the employee was entitled to the protections afforded to her under Section 198A of the LRA. The court reviewed and set aside the award. They declared that the employee was deemed to be an employee of the NPA, and the employee was to be compensated retrospectively in an amount equivalent to the difference between the remuneration and benefits that the NPA paid to its switchboard operators and the remuneration that was paid to her by AFMS over this period. So in short, and to Helen's earlier point, nothing new in respect of TES, but just important again to go its substance over form when it comes to these arrangements. You can call an agreement a service provider agreement, a facilities management agreement, whatever you would like to call it. But if the substance of the relationship is that the client has control and supervision over the employee, they are giving them instructions, they are providing them with work equipment, the employee is integrated into their operations like this switchboard operator, the true substance of the relationship is likely to be that of a TES, and the court in these circumstances will obviously then render the company a TES. Thanks, Helen.
Thanks very much, Nadine. Just to let everyone know, we've got 5 more cases, so we're getting to the pointy end of the updates. Amanda, I think her sound is sorted, but we're going to, before we circle back to her cases, Sean is going to take us through a case dealing with an unfair labour practice. And this again is in the realm of recruitment, looking at the principles around shortlisting. And it's the Department of Higher Education is the case. Thanks, Sean.
Thanks, Helen. So yes, this case deals with an unfair labour practice claim relating to a promotion. The CCMA upheld, they found that an unfair labour practice was committed. The department took the decision on review. The review was dismissed, and it therefore took it on appeal. So the crux of the matter, the facts of the matter, the Department of Education advertised a vacancy for the post of Deputy Principal for Corporate Services in the Tshwane North. And an extensive number of applications were received for the post, including that of the third respondent employee, Mr. Lesetja Frans Sebopela, who I'll refer to as the employee. The requirements of the post included, amongst other things, that you needed an appropriate bachelor's degree or equivalent relevant to the post, and particularly important in this matter, one of the requirements is that you have 5 years relevant work experience. But given the number of applications received, there were an extensive number of applications received, and the department wanted to reduce the number of candidates to be interviewed. So what they did is, via their selection committee, they actually introduced an additional selection criterion by adding additional years of relevant work experience required beyond the 5-year period. So they amended the minimum criteria, and they increased the number of years of experience required. So during arbitration, it was common cause that the department selection and recruitment policy did permit this, and it did allow for the selection committee to introduce additional selection criteria. Based on the changes to the selection criteria, the employee was not shortlisted or interviewed. So because he lacked the relevant years of service based on, the additional years required. So he had initially met all the criteria, but when the additional criteria were introduced, he fell short of that based on his years of service, and he was ultimately not shortlisted. He was aggrieved by this and referred an unfair labour practice dispute to the General Public Service Sectorial Bargaining Council. And at the arbitration, he contended that he was treated unfairly by the department in not being shortlisted, particularly because a less qualified employee, Mr. Sarai, who actually had fewer years of experience than the employee and obviously didn't meet the additional criteria for the additional years of service, was actually shortlisted and interviewed for promotion. Mr. Sarai was not successful, though, in his application, and he was ultimately not appointed to the post. But the arbitrator found that in not shortlisting and interviewing the employee, the department had committed an unfair labour practice against the employee and was ordered to pay the employee 8 months compensation. Of course, the department was dissatisfied with this award and sought that it be reviewed by the Labour Court. The Labour Court dismissed the review application on the basis that the arbitrator's decision was a reasonable one and that an unfair labour practice had indeed been committed. The department then appealed that decision, and the Labour Appeal Court then stated that the test for review of an arbitration award is similar to that of an unfair dismissal dispute, which we all know is whether the commissioner arrived at a result that a reasonable decision maker on the material before them could not have reached. And they also discussed the various principles that are determined in order to determine whether a promotion is considered fair or an unfair labour practice. They basically said that the determination as to the fairness of a promotion is typically weighted heavily on the evaluation process and justification given for the promotion decision. In terms of promotion policies, an employer is required to act lawfully and adhere to objective standards of fairness and the criteria that it has set for promotion, including its own policies, and to ensure that an eligible employee is provided with a fair opportunity to compete for the post. Conduct that does not allow such an employee a fair opportunity will usually constitute, an unfair labour practice. The evaluation, though, of the suitability of the candidate for promotion is required to be assessed fairly rather than mechanically, and there is a justifiable element of subjectivity or discretion reserved for the employer, which the department had done in their selection and recruitment policy by allowing additional criteria to be included for specific posts. The court stated that to succeed in an unfair labour practice claim relating to promotion usually requires the employee to prove that they were not given a fair opportunity to compete for the post. In order to do this, they may lead evidence that the process was unfair and that despite the employee having the necessary experience, ability and technical qualifications, an unfair appointment was made. The Labour Appeal Court said that the evidence before the arbitrator in this case did not show that the department had committed an unfair act in relation to the employee in the context of a promotion. The Labour Appeal Court disagreed with the Labour Court and said that neither the shortlisting process or the decision not to interview the employee was unfair. It was clear that the selection committee was entitled to impose additional criteria in terms of the department's policy, which it did, to limit the extensive number of applicants that it needed to interview, and there was nothing irrational or unfair about the additional criteria imposed. There was also no dispute that the employee in question lacked the relevant years of experience based on the additional criterion imposed. When they looked at Mr. Sakai, who lacked the relevant experience, they said that even though he lacked this experience and was shortlisted, this was done erroneously and incorrectly. It was a mistake, and because this was picked up by the department, he was actually not appointed to the post, and therefore the fact that he was shortlisted or erroneously shortlisted is not sufficient to prove unfairness on parts of the department against the employee. And the department was shown, not to act in bad faith or with ulterior motive in not, shortlisting the applicant. They also emphasized that the shortlisting of Mr. Sakai didn't prejudice the employee because, one, the employee wouldn't have been appointed because he lacked the additional years of experience, and also because Mr. Sarai was not ultimately appointed to the post for the very reason that he also lacked that additional experience. Therefore, the appeal, the court said that the failure to appoint the employee was not unfair in the circumstances, and that the appeal must, the appeal succeeds. And the Labour Appeal Court also said that because there was no evidence that the employee was treated unfairly, there was no just and equitable basis to award payment of compensation to him. What's also noteworthy is that the Labour Court had said that the department is required to strictly comply with its policies and procedures on selection. And the Labour Appeal Court said that, the Labour Court erred in this, and that, the shortlisting of Mr. Saraya, Mr. Saraya was an error and it was a mistake, and it ultimately did not translate into an unfair labour practice committed against the employee because this was picked up, and therefore there was no actual harm done to the employee. I think the key, there was no order as to costs, and the review application succeeded. I think the key takeaway for this is that obviously the evaluation of the suitability of a candidate for promotion is required to be assessed fairly rather than mechanically, and there is still a justifiable element of subjectivity or discretion reserved for the employer. Having said this, in my view, I think it's important for employees to ensure that their selection and shortlisting processes are applied equitably and in line with their internal policies. It should also be done carefully so that errors in appointments are not made. Because if Mr. Sakai had actually been appointed to the position, or it could not be established that this was a genuine mistake by the department, I think the LSE may have come to a different conclusion. Yeah.
Thanks very much, Sean. And we've seen in those recruitment cases how key documenting the process is, and having that paper trail in place when you get to court, which hopefully you obviously don't ever do. Amanda, we're hoping that your sound issues are sorted and that you're going to take us home. We're circling back to our two cases, our automatically unfair dismissal and unfair dismissal cases relating, well, so not our automatically unfair dismissal case and our case relating to termination of a fixed term contract. And the first one is Marilyn. Amanda, if you want to kick off with that one.
Thanks, Helen. Can you please confirm you can hear me? Can you hear me?
Amanda, we're still battling to hear.
Okay, that's crazy. My laptop audio is completely flat.
Apologies, everyone. I think we're not going to be able to resolve that the technical issue with Amanda's laptop for this session. But what we are going to do is when we send out the update early next week, we will include the snapshot of the cases that Amanda was going to take us through in that summary, so you will have those with you. Apologies, Mandla. We're going to leave those cases, and we'll include those in the summary. And then our final case is Komotso Makapani, one of our senior partners based in our Johannesburg practice area, is going to take us to the case of worldwide staffing versus the metal and engineering industries and others, and this is a strike case. So we're going to end off with something that I know creates a lot of anxiety for many of you who have dialed in. Thank you, Komotso.
Thank you, Helen. I'm not sure if my audio is on.
Is my audio on, Helen?
Okay, thank you. Thank you, and good morning, everyone. So Helen made a nice introduction there. I hope I can keep up the momentum. So the case, as she said, is worldwide staffing, P2 Ltd versus metal and engineering industries, bargaining council, and two employees, Vukeya and Chauke. In essence, as Helen said, this case involves dismissal for participation in a strike, and I guess there are two important principles, known principles. They're not necessarily new, I guess, which it highlights. And for what it's worth, the judge in this matter is Wenke AJ. And that becomes important because I think when I read the case, it was clear to me that it was written by someone probably who's an acting judge. Not because it's a bad case, it's a good case, but I think just the way it was approached. It is someone who's in practice. So this case concerns an application for review and setting aside of an arbitration award in terms of Section 145. And just the background in summary is that the applicant, who is Worldwide Staffing, carries on a business of a TES, and he had contracted with Zest Work Electric Pty Ltd to position 2 employees there. And the employees were Chauke and Vukea, as I said earlier. And there was a strike at the client around August 2022, and the strike was protected. Then the union, Dynamic People's Union of South Africa, gave notice of a secondary strike in support of the demands of Zest permanent employees. So this is the union of the employees Chauke and Vukea. So there were picketing rules agreed between the parties in this strike. And these picketing rules prohibited 3 things. One was the displaying of placards with and banners and similar items containing words or pictures that are defamatory in nature. It also prohibited engaging in insightful, provocative or intimidating behavior. But it also set parameters within which, or designated areas within which employees may peacefully picket. So we said that the strike started in August. So sometime in September, early September, around the 7th of September, the 3rd and 4th respondents attended a picket at Zed's premises, and they joined a group carrying offensive placards with slogans such as cruel, corrupt, Zest, abuse at Zest, one must die, wafa wafa. Okay, wafa wafa, I just added it there, so it's my thing. I'm joking, it's in the judgment. So wafa wafa, and it doesn't seem that there was any dispute at the arbitration that these utterances were grossly unacceptable at the arbitration of the employees. So obviously, as I said earlier, that they went through a disciplinary hearing and they were dismissed. And what was important, however, is that obviously the employees who are aggrieved, or the employees who are aggrieved and referred this to the CCMA, and the CCMA commissioner found that their dismissal was unfair, was substantively unfair. And then the company brought the matter on review to the Labour Court. On review, the applicant attacked the reasoning process in the award on an array of alleged gross irregularities. Essentially, that the arbitrator misconceived the issue, undertook an inquiry in the wrong manner, and failed to properly evaluate the evidence presented at the arbitration. And I guess they argue that that culminated in an unreasonable result or an unreasonable award. The case, the decision of the court is centered around the Quest flexible staffing case. And I think we're all familiar with this case. And perhaps just to pause here before I go further to say, so Zest, the client, was not a party to the proceedings. And one assumes, even though it is not clear from the effects of the case or the background, but one assumes that this may mean that the employees either had not been with Zest for a period longer than 3 months, or that they end above the threshold. Otherwise, one would have expected that it is Zest, apologies, who would then have brought disciplined employees and maybe brought this application. But as it is only Worldwide, the TES company that seems to have taken the discipline and then participated in the process to this point. So that was not clear on the facts. So coming back to the case itself, I was talking about the quest flexible staffing case, and I'm just going to read for everyone who perhaps has not read this case in a while. So this was a decision of the LAC back in 2014. So Quest Flexible Staffing Solutions, P2 Ltd. And the Labour Court said, our courts have repeatedly stated that in order to maintain a distinction between review and appeal, an award of an arbitrator will only be set aside if both the reasons and the results are unreasonable. So that is really the essence of that principle that the judge in this matter relied on in evaluating the evidence. What the commissioner said, I mean, in the evaluation of the evidence, there's a number of repetitions, but the repetitions are really just to say there is no dispute, or there was no dispute before the commissioner that the employees, one, knew the picketing rules. One of them was actually a marshal, the picketing rules. And the employees' defense was that when they realized that the placards contained offensive language, they raised this with the strike conveners. But then they went back to participate in the picket and continue to do so. And they were spotted through videos and pictures which were displayed or showed at the arbitration hearing. The commissioner, the judge found, was wrong in arriving at the conclusion of the decision that their dismissal was unfair, solely on the basis that they had claimed that they had reported this to someone, and importantly, that they did not think that because they were not holding the placards themselves, that they would be disciplined. And also there was an attempt at trying to use collective dismissal as a defense. But the judge found that that was actually not the case, because they were identified for their individual action, although in a collective, participating in a collective matter, they were identified for their participation solely for acquainting themselves and joining this picketing. And he also found that there was no evidence that the employees themselves took any steps apart from their claims that they reported this to these marshals or to the conveners, because no convener was called to testify at the CCMA. And on that basis, he found that the commissioner was wrong in finding that the dismissal was unfair. But what is important, and just what I want to highlight, is that in paragraph 22 of the judgment, for those who want to read the judgment, he says that in applying principles of collective misconduct, the third and fourth respondents were found unblameworthy because they were not directly implicated in the ensuing violence. So that is what he said the commissioner had found. And therefore, he found that their actions were not destructive of the employment relationships or relationship. But the judge's view was that it was grossly irrational for the commissioner to find that the third and fourth respondents were dismissal was unfair, because they were merely witnessing the misconduct of others, which is an expression that I've not heard before, that people were witnessing the misconduct of others when they were themselves participating and singing. And he found that the commissioner therefore proceeded from a wrong premise to start with, and therefore the reasoning from there on suffered. And as a result, he overturned that decision because he felt that it was important for the employees to know that once a strike, once the employees participate in a strike that is protected, but then the rules of the picketing rules are violated, the protectedness of that strike falls away. And that was very important, because on the fact, one of the things that happened here is that the employees or the strike became violent. The employees left the designated area and they started marching in the premises. And there was also a blockage of the entrances. The employees also, seemingly from the evidence, participated in that process. although it seems that this was not evidenced by any photos or any videos. So ultimately, the court found that it has been held that fairness rests at the equilibrium between competing rights and interests, and the enterprise's viability depends very much on the trustworthiness of its staff. Conduct destructive of this trust would render continuous employment untenable and intolerable. And the court went into some exercise in trying to speak about how this is also important as a deterrent, right? To act as a deterrent for people who participate, particularly in violent strikes or in conduct contrary to the picketing rules. Because the judge was of the view that it makes a mockery of the picketing rules if the courts accept that people can willy-nilly just ignore them, because those picketing rules are important to make sure that you protect both interests, the interests of the employer, but also the interests of the employees to enforce their constitutional right. So on that basis, the court found that the dismissal of both employees, Vukaya and Chauke, were substantively fair, and their claim was dismissed, and there was no orders to costs. And just one quote. So this is a code we always use when we make submissions in aggravation, that dismissal in the circumstances was a sensible operational response, or sensible response to an operational risk. And that is how the judge landed his judgment and found that the dismissal of the two employees was correct from the beginning. So yeah, that is the case, Helen. Thank you.
Thanks, Kamoto. I think that's a welcome case for employers facing strike action. And I think, yes, that phrase dismissal is a sensible operational response to risk management is a welcome one when dealing with strikes. Thank you all. We're very appreciative to all of you for dialing in. We hope you found the case law updates informative. We apologize for the technical issues. As you said, the recording will be available. We'll send the updates to early next week, and then please look out for our invitation to our next update. Go well, everyone. Thank you.